Hi, everyone. Welcome to another episode of our Ask Amity show. Today, we wanted to focus on bank accounts and retirement accounts. These usually have, enough money where you're concerned about inheritance. We wanted to dive into each of these type of accounts to advise you on how to ensure that they go through the living trust and that it does not have to go through probate. So Cindy, if you could tell us about just the typical bank accounts.
So bank accounts, that could be your checking account or a savings account, maybe even a CD or something. So with these accounts, you want to make sure that you definitely somehow put it into the trust. So typically there are two ways of funding these accounts into your trust. The first way is to rename the account to the name of your trust. And that is simply done with the custodian, with the bank. And typically what they'll do is transfer all those funds from your personal name account and open up a new account in the name of your living trust, and then transfer those funds to the new account under the name of living trust. The second approach is to name the trust as the beneficiary of those accounts. So there are transfer on death documents or beneficiary designation documents that each of these banks have. And you can ask them to give you that document or have them fill it out for you and make sure that they name the trust as the beneficiary of that account. So typically, the choices here, number 1 and 2, will be dependent on the bank. Some banks will allow you to have those options. Some banks will only have one of the two options. So it'll depend on your bank and your specific situation. If you choose one, the first one where you retitle the account to the name of the trust, that means that your checks may also show the name of the trust, and doesn't provide too much privacy in that way. So I personally prefer the designated beneficiary method to designate the trust as the beneficiary of that bank account, so that you get some privacy there, because no one really see these designations. Only the banks see the designations. They're not provided in your monthly statements or anything, so it's nicely hidden. But in that same sense, you want to make sure that the bank has the record of your designation, because obviously you can't see it on monthly statements, but you want to make sure that they still have that designation and it's updated.
Yeah, and then the next type of account would be retirement accounts. So, we're really pretty familiar with like IRAs, 401ks, maybe pension plan type of things. So these type of retirement accounts, more so or not, do not allow you to actually change or register the owner from yourself to your trust. There's certain requirements and things that must be followed. So in terms of retitling the account holders for IRAs and 401ks, usually you cannot do that. It still has to be tied to your individual name. So how we get around that is we make sure that you have the designated beneficiaries named. So for a lot of these financial institutions that hold your 401ks and IRAs, they allow you to not only designate one beneficiary, but maybe you have a primary, secondary, and a contingent. So many times when you've created these accounts, they already ask you, during that time frame to designate those primary, maybe perhaps secondary beneficiaries, which is good. So you already have those in place. But as attorneys, we always think worst case scenario, what if your primary and your secondary also pass along with you or around that same time frame? Then that account may end up still going through probate. So what we advise is for your very last contingent beneficiary, put the trust there. Because within the trust, we usually have backup beneficiaries. So again, if you have a primary beneficiary, secondary beneficiary, if all of those pass, then you have your third in line beneficiary. If that person also passes, then maybe it goes to all the grandkids and their kids and so forth. So as long as you have those language within your trust, which we would advise you when we're handling your trust documents, then you can ensure that these retirement accounts will not go through probate. And that's really our main concern, because again, probate, you have to wait a long time, and your beneficiaries generally have to pay a pretty significant fee in order to inherit whatever you leave behind. So that's basically it for retirement accounts. So just make sure that all your beneficiaries are designated, and make sure that the trust is designated as a contingent beneficiary, last in line, just in case the primary and secondary have passed.
If you have any other additional questions regarding bank accounts, retirement accounts, your estate plan, living trust, anything that's related to those topics, give us a call. We here at Amity Law Group would love to assist you, and we're different from other firms because we not only will help you draft the documents, but we'll also assist you in funding those accounts, such as the bank accounts and the retirement accounts. We've talked to lots of banks and lots of retirement account custodians to try and assist our clients in making sure that those accounts are correctly funded into the trust. So give us a call.